For judgment, item number 30.
On a careful perusal of the judgment and order referred to above, this court is unable to accept the submission of the learned counsel for the petitioner that the service of the petitioner has to be counted only with effect from 9/12/1998. That is the date on which the petitioner was regularized in service for the purpose of computing 35 years of service for releasing the petitioner from public employment. On the other hand, in view of the judicial pronouncement of the definition of public employment as defined in section 2 of the Act 1991, the service rendered by the petitioner on contract basis commencing from 1/4/1988 is to become computed for the purpose of computing 35 years of public service as provided for in section 3(1) and section 3(2) of the Nagaland Retirement from Public Employment Second Amendment Act, provided that the service rendered by the petitioner on contract basis is followed by regularization or regular appointment without any break or gap in service. The petitioner cannot be allowed to accept the revised final seniority list for availing the benefit of seniority and consequential promotions and reject the same when the petitioner's 35 years length of service is counted from 1/4/1988 for releasing the petitioner from service under the Second Amendment Act 2009. The petitioner cannot be allowed to abrogate and reprobate on the revised seniority list where the petitioner's date of entry into service is recorded as 1/4/1988. This court is therefore of the view that there is continuity in the service of the petitioner with effect from 1/4/1988, and the state respondents has committed no infirmity in issuing the notification dated 21/11/2022, releasing the petitioner from service on 31/3/2023 on completion of 35 years of service by taking 1/4/1988 as the date of the petitioner's entry into government service. Writ petition is devoid of merit, dismissed. Okay.
May I please, Lordship?
Yes.
Lordship, I beg to mention item number 35 and 36, Lordship, from the supplementary. Lordship,
Supplementary.
yes, Lordship. Lordship, if this matter can be listed in the first week of November, Lordship, after the vacation, I've taken the consent of the parties, Lordship.
Okay. You're
I'm for respondent number
10.
Yes, Lordship.
Private respondent?
No, Lordship, AG.
Okay. Mr. Ann Musley, then standing counsel, accountant general, seeks adjournment of the case
To be listed on 4th, Lordship, 4th of November.
on 4/11/2024.
Lordship.
Where is allowed? Listed.
Obligation, Lordship.
Yes, Mr. Lima.
Worship, I'd like to make a mention on behalf of my friend Benang Wapang. Worship, item number 20, 21, and 22. Worship, these are part meter, but worship, because of some family problem he's facing now.
Item
20, 21, and 22.
20.
20, 21, and 22.
This is parted.
Part meter, worship.
But look at the
But
matter.
worship, only last night his nephew passed away.
Oh,
Because of that, he could not attend the photo. Worship.
so if it is parted, we have to release it. Mr.
Lordship,
TB,
Lordship, it's okay.
I thought at least we will have this for hearing today. Mr. Lima Wabang makes a mention on behalf of Mr. Bendang Wabang, the learned counsel for the petitioner, and seeks adjournment of the case for a week
Yes, worship.
on the ground of bereavement. Prayer is allowed. Listed after a week. The case is released from part heard. Okay.
Worship,
Okay.
Lordship, I also like to mention item number 29. Lordship, I'm for the petitioner in this case.
Yes, Mr.
Maybe
Lim.
that after 1 week,
Okay. You're for the petitioner?
I'm for the petitioner.
Mr. Limawabang, learned counsel for the petitioner makes a mention, six adjournment of the case after a week.
After a week.
Prayer is allowed, listed accordingly. Okay.
My pleasure, Lordship.
Yes.
Lordship, I beg to mention item number 26 and 27 on behalf of my seniors and the younger Lordship.
Yes,
Lordship, I pray that this matter may kindly be listed after 3 weeks, Your Lordship.
3 weeks. Your good name,
Mr. Nokole M. Konyak,
Mr. So-and-so. Learned counsel makes a mention on behalf of Mr. Santi Younger. The learned counsel for the petitioner and six adjournment of the case for 3 weeks.
3 weeks, Your Lordship.
Prayer is allowed, listed accordingly. Okay,
Lordship, similar prayer for item number 28.
28. Cynthia Younger, same.
Yes, Your Lordship.
Yes, same. Item 28.
Deeply of pleasure.
May I please, Your
Yes,
Lordship.
ma'am.
Lordship, I beg to mention item number 23, 24, and 25, Your Lordship. Hiring item number 20.
You were supposed.
Yes, Your Lordship. So, Lordship, it appears that there is some discrepancies in the post title and the affidavit, Your Lordship. So I may have to
Ah.
amend the petition, Your Lordship.
Okay, so. So what do we do now? Release
So-
it after 2 weeks,
After 3 weeks, Lordship.
after 3 weeks,
Yes.
on the prayer of MSS two. Learned counsel for the petitioner, listed after 3 weeks. Kindly see that you rectify that defect. No?
Lordship, I
You
may
have, you
allowed
have seen,
to.
nah? You have seen
Yes, I may
in
be
the
allowed
post
to.
title and in the affidavit.
Yes, Your Lordship. So
Ah.
I may have to amend the petition, Your Lordship.
Yes, I feel so. So study carefully,
Lordship,
discuss with your client and then come with an application.
Lordship,
Okay?
Lordship.
Okay.
Much obliged.
May I please, Your Lordship?
Yes,
Lordship, I beg to mention item number 1.
item 1,
Yes, Your Lordship. I have instruction to appear on behalf of YB Gupta, Your Lordship, CGC.
item 1.
Yes, Your Lordship.
Wait, let the matter be called at least, without calling the matter you are mentioning.
From the supplementary cost list for admission, item number 31.
We have kept the word.
Yes, my lord.
We have kept our word,
Yes, my
saying that it will be first parted item.
lord. We're grateful, my lord.
Yes, madam.
Yes, your lordship.
Yes, have you gone through this
I have your lordship.
the full bench? And what is your submission on this? It is very clear, very clear.
Certain clarifications. will be made.
Yes, please. You are at liberty.
Lordship,
Yes.
in
yes,
my read petition,
Yes.
my prayer, lordship, first of all, my
Yes,
prayer
wait, Yes, wait,
is-
yes, wait,
yes,
yes,
your
wait.
lordship.
Yes.
My prayer, lordship. My prayer is to quash and set aside the eviction, the restraining eviction, as well as the cancellation of the pata of the petitioners. That is my prayer, lordship.
Yes.
Lordship,
Just wait. You are referring to the main writ petition, correct?
yes, your lordship. Page number 18, your lordship.
This is writ petition 58.
Yes, your lordship. 58. page number 18.
Yes, please read your prayer.
My prayer, number one is to show cause as to why respondent number 3 should not be stopped from evicting the land in question from his land, white land, pata, so and so. And further, after hearing the parties, be pleased to quash and set aside the impugned cancellation order, restraining order, and eviction order, Lordship.
Which, and after, and further after hearing the parties.
Yes, Your Lordship.
Please to question set aside. Okay, man. Yes.
Lordship, secondly, I may be allowed to rely on 2024-6 SEC 1, which the respondent number 6 has relied upon yesterday, Lordship.
Do you have the book?
Lordship,
Mr. Jamomi, are we not getting this book?
I haven't got the volume yet, Your Lordship.
Ah,
I haven't
not
got
yet.
it yet.
whether it is there in the library. Let us just check up. It is 2024
6
6
SEC 1.
because it is a constitutional bench
It is, my lord.
Yes.
4-1 majority.
Yes, my lord. Even the separate judgment concurs with the majority judgment insofar as 226(3) is concerned.
226, correct. But 226(3), the dissenting view is that actually it is a directory. Directory.
Agree.
It is directory.
Yes.
My lord.
Dissenting view.
Yes, my lord.
Correct.
No, no, my lord. It is a
Ah.
concurring view.
No, no.
No.
In the constitution bench judgment, my lord.
Yes, in the constitution bench, the dissenting view.
My lord.
Just have a look.
Yes, my lord. At paragraph 6 of the concurring judgment.
This is by Asanuddin.
No, my lord, this is by Justice Pankaj Mithal.
Just wait, just wait. Proceed. This is regarding this High Court Bar Association.
Yes, my lord. The High Court Bar Association of Allahabad.
Kach Mittal, yes.
Yes, my lord.
Kach Mittal.
Yes, my lord.
Just,
Paragraph 6,
no, paragraph, you just read paragraph 3.
my lord.
3.
My lord, the above directions in Asian resurfacing issued in exercise of power, paragraph 2, paragraph 3, my lord. No doubt, the above provision in respect to petitions filed before the High Court invoking the extraordinary jurisdiction of the court and is not meant to be applied specifically to other proceedings. Nonetheless, the principles behind a said provision can always be extended to other proceedings as has been done in Asian resurfacing. It is worth noting that wherever under any statute, any such time limit has been prescribed or is fixed for deciding a particular nature of proceeding, it has been held to be directory in nature rather than mandatory. So appears to be the position with regard to the applicability of 226(3) of the Constitution of India.
Ah.
So appears. But then if your lordship will come to paragraph 6,
Ah,
paragraph 6 of the same judgment of Justice Mittal. 6. It is noticeable that under Article 226(3) of the Constitution of India, the automatic vacation of the stay order envisages making an application to the High Court for a vacation of the interim stay order. Therefore, filing of an application for vacating the stay order is a sine qua non.
ah,
So it is actually a concurring judgment, Your Lordship. It is actually a concurring judgment. It is not a dissenting judgment. And as Your Lordship will appreciate, the judgment must be read in its entirety, not in bits and pieces. So this is the conclusion, Your Lordship. For triggering the automatic vacation of stay under Article 296.
let us see this, please call for this book. This is 2024-6.
6 SEC 1.
I think we have
Yeah, I think Your Lordship has the monthly
Ah.
volumes.
some monthly. 2024-6. SSC, yes, 1. This is. No, I think there's something wrong. This is interplay between arbitration agreements under Arbitration and Conciliation Act.
Maybe the citation is.
267, not page 1, 267. Just see. Not one. 267. 267, okay. 267, not one.
Where is it? Where's the Show me that.
You take the citation and give. Yes. 267. Okay, waiting for the book. Yes,
My
ma'am,
lord.
let us see.
Lordship, since
Full bench, full bench.
my learned senior counsel has relied upon this very citation, case laws, Lordship. So if I may able to allow to go through paragraph number 14, Lordship.
Paragraph 14.
Uh,
I don't know whether we are having the same,
Yes, Your Lordship. Since there is some confusion with regard to the pages.
267.
huh. No. Let's just tell them, I can actually I have actually marked in this. Yeah, paragraph 14, yes.
Yes, Your Lordship. High Court's power to vacate or modify interim
Ah.
relief, Your Lordship. I may be allowed to read, small para. When the High Court grants a stay of the proceeding while issuing notice without giving an opportunity of being heard to the contesting party, it is not an interim order, but it is an ad interim order of stay. It can be converted into an interim order of stay only after an opportunity of being heard granted on the prayer of the interim relief to all the parties to the proceeding. Ad interim orders by their very nature should be of limited duration. Therefore, such order do not pose any problem. Lordship, and para 26, Lordship. Para 26. Lordship, para 26. Para 26, it explains.
Yes.
Lordship, here, in this case, it is unnecessary for this court to decide whether clause 3 of Article 26 of the Constitution here is mandatory directive. Clause 3 of the article read thus. So, Lordship, this was the explanation, and then this was the observation that was made, Lordship. The next para. Lordship, the next para, I may be allowed to read, Your Lordship.
Yes, please.
Yes, sir. Lordship. The next para.
Yes, wait, yes. Yes, excuse me. Yes, on its plain reading.
On its plain reading, clause 3 is applicable only when an interim relief is granted without furnishing a copy of the writ petition along with supporting documents to the opposite party and without hearing the opposite party. Even assuming that clause 3 is not directory, it provides for an automatic vacation of interim relief only if the aggrieved party makes an application for vacating the interim relief and when the application for vacating stay is not heard within the time specified. Clause 3 will not apply when an interim order in a writ petition under 226 is passed after the service of copy of the writ petition of all the concerned party and after giving them opportunity of being heard. It applies only to ex parte at
Here-
interim order, Your Lordship.
Here, the interim order was passed without hearing the applicant. That is the issue.
Yes, Your Lordship, in a way, but Your Lordship is also very much aware that regarding the ex interim party, Your Lordship, at interim, ex parte at interim, Your Lordship, Lordship is also aware that it is an order which is temporarily passed or it is during an intervening period, Your Lordship. It is given for only for a limited time, Lordship, but however, on perusal of the interim order dated 22/4/2024, it clearly states that all the parties have been heard, Lordship, all the parties have been heard.
When
But-
actually that order was passed, ma'am,
Yes, Your Lordship.
the
I may be-
applicant was not in the
agree, in a way.
picture.
But, Your Lordship,
Now let us forget let us forget what happened before the status quo. Let us come, what happened after the status quo?
yes, after the status quo, Your Lordship, by order dated 4/6/2024, the applicant number 6, the respondent number 6, the applicant herein, was impleted by order dated 4/6/2024. While the impugned order, Your Lordship, the interim order was in effect, the petitioner filed a contempt petition, Lordship. After they have been impleted, Lordship, after they have been impleted, since there was a disturbance in the disputed land, because the respondents,
Madam.
Lordship, what I
with the
want to say
understanding of this
is,
code, I have understood your
yes,
case.
Lordship,
You want to bring in the merit, but I'm not going into the merit.
agree, but
I am
Lordship,
just on 226(3). That's all. Whether the 226(3) as held by the full bench of this court is mandatory or direct. I'm only on that. And if you see the full bench judgment, 226(3), insofar as constitutional provisions are concerned, I think there is no exception.
then Your
That
Lordship,
has been held by
if I
the
may
full bench.
mention, if I may be able to allow to describe on the listing of the dates. Listing of the dates.
No,
of the
listing of the
vacation
dates,
application.
see,
Listing of the dates
see.
of the vacation
See,
application,
madam,
Your Lordship.
Have you read this full bench?
I did, Your
The
Lordship.
full bench says that actually the date on which you have received the application or the date on which it is first listed,
Yes, Your Lordship.
whichever is
Agree.
later.
But
So we count
whether-
the date from that.
agree, Your Lordship.
And,
Then I may be
even
allowed
suppose-
to
even-
satisfy Your Lordship
Even
regarding
suppose, if there is some lapses on the part of the court,
act of
I
omission,
think
Your Lordship.
there is no exception to that. Constitutional provisions, the full bench has held that there can be no exception insofar as constitutional provisions are concerned. I think last night I have given enough time to read the entire judgment.
Mhm.
So
Lordship, whether the question of act of omission will lie in this present case, Your Lordship.
let us see the judgment. Let me just where is that full bench? So yes. Let us read some paragraphs which will make our case very clear. Yes, let us, Mr. Jimami, let us also read para 27. Let us read para 27 of the full bench. I think something is very clear in this. Yes, can you read?
Yes, Your Lordship.
I'll do that now.
I'll listen to you.
Yes, or you read,
No, no, GLT. GLT. I'll read it, madam.
you have the book,
I have the order, Your Lordship. I
Yeah,
have the judgment.
judgment.
Yes.
Kindly ponder over this. I will give some paragraphs and let us read this. I'll
The
give some
above-
paragraphs.
The above meaning ascribed to the terms
Huh.
directory and mandatory shows that when a provision is mandatory or absolute, the provision has to be obeyed or fulfilled exactly. However, a directory provision only requires substantial compliance. The question therefore arises as to whether a constitutional provision, which is the basic law of the nation, can be said to be directory or requiring substantial compliance only. We are of the opinion that taking into consideration the place of a constitution or constitutional provision holds which is the supreme law of our nation, a constitutional provision cannot be said or declared to be a directory or requiring substantial compliance only. The framer of our constitution, as well as the evolution of the constitutional law, as referred to herein above, nowhere conceived that a constitutional provision would be directory. No doubt a statutory provision or contractual provision of or a term of a tender document can be held to be mandatory or directory on the basis of the language used, coupled with the intention of the legislature or the parties respectively, but the said principle of interpretation, in our opinion, cannot be imported to interpret a constitutional provision to be mandatory or directory. In our opinion, declaring a constitutional provision to be directory would not only result in demeaning or diluting the powers of the parliament under Article 368 of the Constitution, which is also an essential feature of the basic structure of the Constitution, but would also go against the various judicial pronouncements which hold that the power of the parliament to amend the Constitution is plenary and wide, and the parliament can amend every aspect of the Constitution, except abrogating the Constitution or changing the essential features forming the basic structure of the Constitution. In addition to the above, we also find it opposite to observe that except the judgments holding that Article 2263 of the Constitution to be directory, we have not come across any judgment holding that a constitutional provision is directory. The reason seems to be obvious in as much as the Constitution is the supreme law of the land. We are further of the view that the constitutional provision inserted to the Constitution by way of amendment can be struck down on the ground that the said amendment infringes the basic structure of the Constitution, forming the constitutional core of our Constitution, or given an interpretation which would be conducive to the changing times, taking into account that our Constitution is a living document, but under no circumstances a constitutional provision can be said to be directory, save and except where the Constitution itself states so.
Yes, what
Yes,
do you
agree.
understand?
I've understood, Your Lordship. I've understood clearly.
Yes,
But I've raised the question whether it has to do with an ad
so also
interim-
31, let us see 31. 31, read please, ma'am.
Yes, Your Lordship. The Constitution Bench of the Supreme Court in the case of Chief Justice of Andhra Pradesh also dealt with the principle of interpretation of a constitutional provision. It was observed that normally a constitutional or statutory provision should be construed according to the intent of that day that made it. Normally, such intent is gathered from the language of the provision, and if the language of the phraseology employed is precise and plain, and thus by itself proclaims the legislative intent in unequivocal terms, the same must be given effect to
Effective,
regardless
Regardless of the consequences that may
Agree.
follow.
that may follow.
See, I think it's very clear. Regardless of the consequences that may follow. So, of course,
Your Lordship,
I have to hear you, but I think the judgment cited by the learned counsel for the applicant is very clear.
agree, Your Lordship.
This has
It is-
this court in reference has decided
Yes, Lordship.
as to whether it is directory or mandatory.
Yes, Lordship. It's
So-
clear, Your Lordship. It's clear.
So
Correct.
I cannot go beyond the bound of this full bench judgment.
Yes, Your Lordship. It's correct.
So
Even the Supreme Court judgment, madam.
uh,
Even the Supreme Court judgment.
Supreme Court judgment, of which para was relied, I think, just wait.
Paragraph 26, my lord.
Which is para 14, which is para 38 of the full bench judgment.
Yes, my lord.
Para 38. What is para? I think now we have to refer to this.
Yes, madam.
Para 30, let us see. Well, how does this para starts, Mr. Ijmo?
I'll get back to your lordship, madam.
Or, oh, you are having the book.
I'm not having the SEC, my lord.
Can you kindly?
Very well.
Yes. We will hear you, madam, still. But now we are on the judgment decided by the full bench,
Yes, Lord.
which has relied on the judgment passed by the Honorable Supreme Court. This para 38 of the Honorable Supreme Court's decision
Para 38 is in the full bench, my lord. In para 38,
in para 14.
in
of the
para
full bench.
38, they refer to paragraph 14 of this judgment.
Yes.
Yes, my lord. So paragraph 14, I'm just getting that paragraph, madam. In the from the website printout, your lordship, paragraph, this particular paragraph is paragraph 16. But in the report, your lordship, it is paragraph 16.
Let us see.
So it is correct, your lordship. What is mentioned in the number mentioned in the full bench, it is correct.
The full bench has referred to this.
Yes, ma'am. So the number mentioned in the full bench,
That's
paragraph number mentioned in the
yes,
full page
that-
judgment is
yes.
correct.
This High Court's power to vacate or modify.
Yes,
interim
my
order.
lord, that's right. Then whether the paragraph 45 is also the same, my lord?
Yeah, yes.
Even para 15, Your Lordship. 15.
Which are the para 16. Para 16 and, ma'am,
Your Lordship, 14, 15, Your Lordship.
para 14, 15, 16.
Yes. There are other grounds for vacation, Your Lordship.
Okay, we will just refer to this.
So then it will come after
14?
paragraph 16. So in the Supreme Court citation, it should be paragraph 16, 17, 18, presumably, my lord.
16, 17.
The high courts are 17 should be the high courts are always empowered to vacate.
On this grounds, but I
Yes, ma'am.
think this is not relevant
Yes, my lord.
on this ground, because now we are.
Only on 226.
226(3). 16. Yes, ma'am. Now let us again hear you. Back to you. Yes, ma'am.
Lordship, as per going by the merit of the case, my learned friend has stated that
Should we,
That can-
should we go into the merit?
since Lordship mandatory, it's clearly as per the latest judgment, Your Lordship, landmark judgment, it's been clearly stated. But however, Your Lordship, if I go by paragraph number 15 of the SEC, Your Lordship, of the criminal appeal, as per paragraph 15, it says the High Court are always empowered to vacate or modify an order of interim relief, Your
Ah.
Lordship, passed after hearing the parties on the following grounds, amongst other grounds, Your Lord. There are other grounds also, Your Lordship.
No,
Yeah,
no,
that's
that is in the ordinary course of vacating the interim. Now we are on 226(3). That is the limited issue before this court. Am I right?
Yes, ma'am.
We are not on the interim order passed by this court. Of course, interim order, of course, it can be vacated on such and such grounds. But here is a question, whether actually the status quo order passed by this court should be vacated by operation of law under 226(3). That is the limited issue. And so far as the merit or so far as the other facts of the case is concerned, this court will not go into that in this IA.
Then, your lordship, whether the question of act of omission, lordship, in this particular case will lie when it comes
That
to
has been answered by the full bench,
agree.
irrespective of the consequences
Yes.
that may follow. See, it may be the fault of the court, or it may be the fault of the party. But insofar as the constitutional provision is concerned, it is
Yes,
made
lordship.
mandatory, irrespective of the consequences that follows. So that is the law which has been held by the full bench, and unless that is actually overturned or overruled by a body which is higher than that, well,
Lordship,
maybe
on
this
that
court
line,
is helpless.
I don't have any points to argue on that line because it's already been admitted that it is mandatory, your lordship, as per the latest judgment that has been given. And then moreover, your lordship, if in the judgment GLT4, your lordship,
Yes.
one thing the constitutional bench has mentioned and made observation was regarding on the fault of the registry also, your lordship, on the fault of the registry, whether that can be considered or not. But it was just an observation that
That was just a passing remark.
Yes,
No,
just an
passing remark.
observation, your lordship. But
So
how-
see, madam,
just, you know,
madam, full bench has actually relied in a paragraph or two of the decision made by the Supreme Court. And relying on those decisions, the full bench has held that actually Article 226(3) is mandatory. See, so how can this court go beyond that? You actually give me a way so that I will actually jump over. That is the only way.
lordship, in this, it's clearly stated that it's mandatory, lordship. I agree on that part.
Yes.
But however, can the
And,
petitioner,
and ma'am, let
Yes,
me just
Lordship.
tell you, it has been held to be mandatory. Another line, you add that, irrespective of
The
the
consequences.
consequences. So irrespective of the consequences means, irrespective of whether there is the fault of the court or whether there is the fault of the registry, fault of the parties, I take it that way.
should then here, conclusion. Lordship, in the
Yes.
conclusion,
Yes.
of the criminal appeal,
No,
SSC
madam,
regarding the,
criminal appeal,
yes.
those facts are entirely different. That
This-
is with regard to the powers of the Supreme Court under
this was
142.
the observation that was made.
So it was just it was just a observation that was made in 226(3). But actually the issue before the Supreme Court was 142, Article
Your-
142.
Agree.
Oh,
Yes, your lordship. Under 142,
yes, so the full bench has extracted one paragraph which it found relevant.
Hmm.
And giving its own observation, relying on various catching up decisions passed by the Honorable Supreme Court. It has held that it is direct, mandatory, not direct. So insofar as low point is concerned, I think
agree.
we should abide by the full bench decision so far. If there is another thing left, of course, we can hear you, but so far as the low point is concerned, I think you have also gone through.
I've gone through.
I've also gone through, this court has also gone through, and then this court has actually found that actually reading so many paragraphs, relevant paragraphs, I think there are 5-6 paragraphs from where we can gather that actually the 226(3) is mandatory. And it is mandatory irrespective of the consequences that follows. That is what this court has actually read. So to this 226(3), insofar as the IA is concerned, I think
Your lordship.
with due respect to you,
Yes, your lordship.
I think we.
No, I have the merit. No, I have
Yes,
the
you do.
grounds.
We are not touching.
Yes,
on
Your
that. We
Lordship.
will not touch
Yes,
on
Lord.
merit. And the matter, the fact still remains that the matter is still pending before the commissioner now.
Yes, Lordship.
The merit.
But the application is only for vacation, Your Lordship, in this hearing of the IA.
Hearing-
only for vacation.
This is for vacation. And during which the 226 tree is a relevant subject
Yes, Lordship,
in the IA.
agree.
Is
It's
a
only for
relevant
the
sub-
disposal of the IA, not for the.
And that is why
election, Your
on
Lordship.
the earlier occasion, the counsel for the applicant has been very shrewd. He has always kept 226 tree alive.
Yes, that's true. That's true.
So
I appreciate on that, Your Lordship. Yes.
maybe even without, in the IA also, even without going into the merit, without going into those nitty gritty of facts, I think 226 tree on the basis of the full bench judgment.
Your Lordship, if I may, Your Lordship, so that we don't miss out on the directions of the Supreme Court. Even the Supreme Court, Your Lordship.
Yes.
Well, the answer is already there as far as 226 is concerned.
So we so far as the IA is concerned, we leave it reserved
Yes, madam.
because this court also may have to go thoroughly through the judgment
Very well.
Yes, Lord.
to give my decision in this item. Heard Mr. K. Jimomi, the learned standing counsel. Gauhati High Court, Kohima Bench. And MS Santila. Naksantila, I'm sorry,
Yes.
the learned counsel. For the opposite party petitioner. The parties in line on the IA 101/2024 and
102, madam.
102/2024. Judgment and order is. Okay, let me also go through.
Yes, madam. Much obliged.
So
Much obliged.
see this, na? This GLT, this one, na? From this page till the end. Really? Tell me to make photocopy and give it. Hey. Tell me to make photocopy and give it. This. Okay. And also this by today itself. Okay. And also this to all the judgment. Okay, the whole judgment. Okay. This to along with the files. Okay. Okay, tell them to give me clear photocopies. Okay.
For admission, item number 1.
Yes.
May I please, Your Lordship?
Yes.
Your Lordship, I have instruction to appear on behalf of YB Gupta, Your Lordship, corresponding 105. Your Lordship is, as a counsel is having some personal difficulties, so I believe if this matter could be adjourned for 1 week, Your Lordship.
Mr. So-and-so. Learned counsel makes a mention on behalf of Mr. YB Gupta. The learned CGC. And seeks adjournment of the case for a week. Prayer is allowed, listed accordingly.
Obliged, Your Lordship.
For admission, item number 2.
Yes, Mr. Tongpo,
Yes, your lordship.
what is the matter?
Your lordship, it is to do with the petitioners who were appointed as constables general duty after they were selected for the post of lab technicians. So by
Yes, who is for the government? Who is for the government? The government was supposed to file affidavit.
yes, affidavit has been filed. I have received a copy of it here.
Tiba, Tiba. Ha. Affidavit has been filed.
Yes.
What is the date of the affidavit?
Yes, only this morning I have received it. I am informed it was filed only this morning.
Only the, what is the date? What is the date?
It is today's date only, your lordship.
Today's date.
Today's date only. It was filed only this morning.
Today is क्या? 2022.
Yes.
22. 20 years, it will not be there. Okay.
This morning on the rise.
In terms of the order dated 12/9/2024, the state respondents have filed the affidavit. Only this morning, only today. So the affidavit filed by the state respondent is however not on record. Registry to place on record, listed after
After the vacation, your lordship.
listed after a week,
Yes, your lordship.
listed, okay,
Okay.
listed after a week.
Much obliged.
For admission, item number 3.
Wait, please, Lordship.
Yes, Ms. Ma.
Lordship, by order dated 20 September 2024, Lordship, the Leonard CGC, Mr. Gauhati was given 4 weeks' time, Lordship, and there's also a specific order that if no affidavit is filed on the next day, the court shall consider passing appropriate orders against the state respondents, Lordship.
Who are the respondents?
Lordship, the Union of India and the Railways, Lordship, represented by Mr. Gauhati, Lordship, CGC.
May I please, your lordship? Your lordship, my senior was representing for the respondent 1, 5, 6, and 7, your lordship. However,
It's all right, it's all right.
however, on dated 29/24, your
It's all
lordship.
right, this court has understood.
Yes, ma'am.
This court has understood. So 1, 5, 6, 7, correct?
Yes,
1,
Lordship.
5, 6, 7.
Lordship.
What is your case?
Lordship, payment of land compensation, Lordship, for constructing railways and the quarters, Lordship. I have to need it. My land has been acquired illegally, Lordship. That is my contingent. 8 acres of land in the year 1984, Lordship.
Where?
Tuli, Lordship, under Mojo
Oh,
district.
Tuli.
Tuli, Lordship. The state has filed the affidavit, admitted that it has been verified. No land compensation has been paid. That is the contention of the state respondents, Lordship.
Whether notice has been served upon this. What do we do, Mr. Mua?
Lordship.
What is the best record? Because actually like, since the railway is the agency which has to pay you the compensation.
Lordship.
It may be proper to hear them also, no?
Lordship, yes, Lordship, I agree.
Heard. We actually furnished the copy of the order 29/2024
Lordship,
and no, we furnished the copy which is to be passed today
Lordship,
to the railways
Lordship,
through the registry.
Lordship.
We direct them, okay? Heard Mr. Mojamir, the learned counsel for the petitioner. Mr. E. Chabapong, learned government advocate, appears for the state respondent number 1,
No, my lord, 2, 3, 4,
2, 3, 4,
and 8.
and 8. None appears, and 8, stop. There is, however, no representation on behalf of the Union of India / Northeast Frontier Railways. No, there is no representation on behalf of the Union of India nor the railway authorities who are implemented as the respondent number 1, 5, 6, and 7. This code on 29/2024 has passed the following orders. Ma'am, 29/2024, the whole order, okay? So, however, in spite of in spite of the order passed on 29/2024, there is no representation on behalf of the Union of India and the railway authorities and the railway respondents. Stop, new para. This court therefore deems it appropriate to give one more opportunity to the Union of India and the railway authorities who are the respondent number 1, 5, 6,
And 7.
and 7. To appear and prosecute the case. Stop. It is made very clear that if there is no representation on behalf of the said respondents on the next date fixed, this court shall proceed to hear and dispose the case on the basis of the materials available on record. Stop. The registry of this court shall furnish the copy of the order passed by this court today to the respondent number 1, 5, 6, and 7 within 3 days from today. listed again after,
3 weeks, Lordship.
listed again after 3 weeks.
Obliged, Lordship. Much obliged.
For admission, item number 4.
Yes, what is this?
Lordship, the counsel for the petitioners, Mr. Subangwati, is engaged in court 3, Your Lordship.
Okay.
I was instructed to seek for 3 weeks' time to file affidavit in reply to the additional affidavit filed by the state respondents, Your Lordship.
Okay, okay. The learned counsel for the petitioner is granted 3 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents listed accordingly.
Deputy Lordship.
For admission, item number 5.
My please, Lordship. My lord, I'm yet to receive instruction, so kindly allow me 3 weeks' time, my lord.
No objection.
I'm appearing for respond number 1, 2, and 3.
Lordship, there's an interim.
Who is for private respondents?
Lordship, I'm for R4,
4 and 5.
only 4, Lordship.
What about 5, Mr. Puseko?
Five.
Sir,
Lordship, didn't serve
didn't serve.
by order dated 29/8/2024.
Okay. So have you filed your affidavit?
Yes, Lordship.
Okay. How much time, Mr. Tiba?
My lord, 3 weeks' time, my lord.
Mr. E. Tibapom, the learned government advocate, is allowed 3 weeks' time to file affidavit in opposition on behalf of the state respondents. Stop. The interim order passed earlier shall continue till the next returnable date. Okay.
Obliged, much obliged.
For admission, item numbers 6 and 7.
May I please, Your Lordship. Lordship, I'm appearing on behalf of learned counsel Stephen Yantan, who is representing all the respondents.
Represent- Even the state. Oh, whether state is not a party?
State is not part.
That is not a party, Your
State is
Lordship.
not a party?
Yes, Lordship.
Oh, development authority.
Yes.
What is your case, ma'am?
I'm praying for consideration of seniority.
Okay. Okay. You have not filed your affidavit
Not yet, Lordship.
on behalf of 1, 2, and 3.
Yes, Lordship.
How much time you require?
Lordship, we may be given 4 weeks' time.
4 weeks is too much. Let us bargain with 3 weeks.
Okay, Lordship.
Mr. Your good name,
Abel, I am, Your Lordship.
so and so. Makes a mention on behalf of Mr.
Stephen Yantan.
Stephen Yanton. The learned counsel for the respondent number 1, 2, and 3, and 6 adjournment of case for 3 weeks to file affidavit in opposition. Prayer is allowed, listed accordingly. Okay?
Obliged, Your Lordship.
Item number 8.
Your Lordship,
Yes,
here I have sought for certain clarifications, so kindly grant me 3 weeks' time.
you
to
have
file my
received the
appeal.
instructions.
Yes, Your Lordship, but clarifications are sought.
Okay. What are the state respondents?
Yes, Your Lordship.
Okay, MS, AIME. The learned government advocate submits that she has received the instructions. However, further clarification is required. She may therefore be allowed 2 weeks' time to receive the instructions and file affidavit if so advised.
Much obliged.
Prayer is allowed, listed accordingly.
For admission, item number 9.
May I please, Your Lordship? Lordship, I'm for respondent number 5. Lordship, kindly grant me 3 weeks' time to file my affidavit in opposition, Lordship.
What about the state?
Lordship, I'm for respondent 1 to 4 and I'm yet to file my affidavit, so 3 weeks time may be granted.
You were standing there as if you have filed. Huh? You are for the 1, 1, 2,
to
and
4.
3. 1 to 4.
Lordship.
Correct. Mm. MS Pichano, the learned government advocate, as well as your good name,
V Koza, Lordship.
Mr. V. Koza, the learned counsel for the respondent number 5, are both allowed 3 weeks' time to file their respective affidavit in opposition, listed accordingly. Much obliged.
Item number 10.
Yes, Mr. Tongpok,
Your Lordship, the matter is,
affidavit for dusty service upon respondent number 5 and 6.
yes, but on the last occasion, this honorable court has by order dated 23/9/24,
20, just wait, 23/9.
2024.
Yes. Treated as complete. To once again take steps for service of notice by district opponent. Yes. 5 and 6. Who are
Yes.
5 and 6?
The vigilance 5 is the Lok Ayukta and 6 is the special judge.
Why include the special
Your
judge?
Lordship, it is in his administrative capacity, he only needs to issue a certificate to the effect that there is no case pending before the vigilance, before the special court.
How special judge?
In their case, in the case of others, in the case of similarly situated persons, in order to promote the petitioners, normally a formality is followed, asking the vigilance whether there is any cases pending before the particular officer. So in the case of others, vigilance clearance was given. But in this case, in the case of the petitioner, it was sent to the vigilance, to the Lok Ayukta. Lok Ayukta in turn sent it to the special court to issue the certificate as to whether any, to issue a certificate as to whether.
I am, Mr. Tongpok, I am hearing it for the first time that it is the special judge who issues certificate.
I don't know
I
how
don't
they are
understand,
doing
man.
it. Yes, it is a little strange.
Mr. MT, can you kindly assist this court? Whether you can of course get further information, but whether this district and session judge, special judge Nagaland Lok Ayukta has the capacity to issue certificates, or whether actually Nagaland district and session judge Lok Ayukta is the only to judicial proceedings.
Your Worship, I don't think.
Please.
And in order to implement the trial court, unless there is a exceptional circumstances,
Correct.
it is also not mandated.
That's why,
Yes.
since the trial, since the learned district and session judge is implemented, this court is also well conversant that actually
Yes.
courts should normally not be
Yes, your
implemented
lordship.
unless the court has
Especially-
committed serious illegalities or irregularities.
Yes, your lordship. But here in this case, it is a peculiar kind of case where the only thing is to verify whether there's a case pending before the court against the petitioner or not.
But
But in this case, there is no case pending.
your submission is very simple, but
Yes.
there's some confusion there. Can you kindly take instructions?
Your Lordship,
We'll listen after a week.
Your lordship.
Instructions on what?
As to whether actually a case is pending before the vigilance or not. Because
No, it can't be that. Whether a case is pending or not, that is for you to assert us.
I have clearly made out a case that there is no case pending. But what happens is the department send it to the PNAR, the PNAR in turn send it to the Lok Ayukta. Lok Ayukta in turn forwarded it to the district, to the special judge as to whether there is any case pending in the court against me or not. And now the learned judge is sitting over the matter. That is the only case I have. That is the position, your lordship. Whereas there is no case at all.
No, see,
pending.
if suppose a matter has been referred to the district judge, to try the case. This court cannot give a time bomb.
Your Lordship, in the case of any certificate, normally in the civil matters also, the party, whoever required that, sometimes it comes a statutory requirement. Any suit pending against any particular firm or individual. So in that case, an individual person, they apply to the court and they obtain the certificate. That there is no pending case against a concerned individual. So that can be done. But the thing is whether that in pleading the trial judge, lower learned trial judge, it is mandated and it is reserved in the present case or not. That's the issue here, Your Lordship.
Your Lordship, may kindly turn to page 93. This is the only vigilance, this is the only clearance certificate which is required, Your Lordship. Page 93. This is in respect of two similarly situated officers, Your Lordship, who are junior to the present petitioner. Page 93, annexure Q3. This is from the Department of Personnel and Administrative Reforms Vigilance Branch. Vigilance Clearance Certificate. I am directed to refer to your letter number so-and-so dated 31/1/2024 on the subject cited above and to convey that there are no vigilance cases pending against the following officers.
So you want this kind of
only this certificate because
then how district and session
now
judge
Your
comes
Lordship,
into the picture?
yes, Your Lordship, the position is that they sent for information, they sought seeking information as to whether any case is pending against me before the special court or not, before the vigilance or not. No reply is forthcoming from that end. Because of that, the personnel and administrative branch is unable to issue the certificate. And because of this, now my promotion is kept pending. And in the meantime,
No, the short question is whether the district and session judge court
yes,
is a body competent to issue that certificate.
Your Lordship, only information the court needs to give to the department concerned is that there is no case pending. Or where if there is a case pending, there is a case pending against him. That is the only thing the judge needs to write. So that the Lok Ayukta can inform the PNAR department that there is no case pending, and on the basis of that, this certificate may be issued. But because they have complicated the matter in such a way that it is now before the special judge, and the special judge is not acting on it. And this is the position. The special judge only needs to say whether there is any case pending against me or not. It may not issue a certificate, but just to send back the information that there is no case pending against me. And unless a specific direction is given to the special judge to act on the query that has been sent to him, he is going to sit over the matter and the certificate will not be issued in my case. This is the unique, awkward position I am placed in.
What certificate, clearance certificate? What certificate the district judge is to issue?
They have sought from the district, judge whether there is any cases pending in the in the special court against me or not. Actually, the Lok Ayukta itself could have given the information that there is no cases pending. That would have sufficed, because once it reaches the PNAR department, the PNAR department would have issued the certificate. But in this case, for reasons unknown, the Lok Ayukta decided to put the matter up before the special judge. And the Lok Ayukta is saying that we have put it before the special judge. The special judge has not given us any information. So we cannot write to the PNAR department. And now the case of the government is that we have already put up, but it is not coming, returning, no information is coming. Yes.
I heard Mr. Tongpok Pong.
Lordship, yeah, actually, I find that is an administrative matter. The second session administrative matter.
We will just
Yes.
pass an order requesting you to assist this court.
Yes, and
Nothing.
your lordship, unless the respondent number 5, Lokayuta, if he's responded, I think this matter will linger. Respondent number 5 is Lokayuta. So they will give the clear picture.
No,
Lordship.
since after hearing from the
Yes.
respondent number 6, we may not hear the Lok Ayukta, we may just quash the order passed by Lok Ayukta without hearing because they are failing to give appearance. But so far as district and session judge, I think you can assist this court.
Lordship.
Okay. I heard Mr. Tongpok Pongoner, the learned counsel for the petitioner. Learned counsel for the petitioner. Who is for the respondents? State respondents, additional chief. You, MS
Respondent.
and MS S. Mary, the learned counsel for the
Respondent 1 to 4.
respondent number 1 to 4. Have you filed your affidavit?
Yes, Your
Yes,
Lordship.
respondent number 1 to 4. In the present case, the district and session judge and special judge, Nagaland Lok Ayukta, Nagaland Kohima, is implemented as respondent number 6. The implement of respondent number 6 in the considered opinion of this court may not be necessary. Mr. Stop, this court has however, this court however requests Mr. Imti Imsong, the learned additional advocate general, to seek necessary information from the respondent number 6 as to whether the vigilance clearance certificate, correct?
Yes.
As to whether what
Yes.
vigilance is no more.
Your Lordship, I don't know what is going on down there, but every now and then they are seeking vigilance clearance.
As to
The
whether
departments.
the vigilance clearance certificate. As to whether, I'm sorry, as to whether the issuance of the vigilance clearance certificate is still pending before the respondent number 6. And if so, the reason as to what been issued by the respondent number 6. So, Mr. Im Tim Sung, the learned additional advocate general, Nagaland, is requested to place the necessary instruction as sought for by this court on the next date fixed. Listed after
4 weeks.
listed after 4 weeks. Okay. A copy of this order shall be furnished to Mr. Im Tim Sung, the learned additional AG Nagaland. Okay. Okay, let us see.
For admission, item number 11.
May I please, Your Lordship?
Yes.
Lordship, on behalf of Inaholi, the state is said to file affidavit, so 3 weeks time may be granted, Lordship.
Okay.
Right, Your Lordship.
MS Pichano, the learned government advocate, seeks adjournment of the case on behalf of MS Inaholi. Learned government advocate for 3 weeks to file the affidavit in opposition. Prayer is allowed. Listed accordingly.
Much more.
Item number 12.
May I please, Your Lordship?
Yes.
Lordship, I received my instructions, however, I'm here to file my affidavit, so 3 weeks time may be granted, Lordship.
MS Pichano, the learned government advocate, submits that the necessary instructions have been received and he will be filing the affidavit in opposition within a period of 3 weeks from today. Prayer is allowed. Listed accordingly.
I pledge.
Item number 13.
May I please, Your Lordship?
Yes.
I'm appearing on behalf of Takin Richabo for private respondent number 4.
Ah.
Lordship may kindly allow 3 weeks time to file my affidavit.
For the government,
Lordship, on behalf of Inali, the state also you to file, so 3 weeks time will be granted. Lordship.
the state respondents,
Um,
as well as Mr. Akin Richabu, the learned counsel for the petitioner, for the respondent number
4.
For the respondent number 4, are both allowed 3 weeks time to file their respective affidavit. in
Maybe
opposition.
Lordship, there's a similar case, 141 of 2024. If Lordship may kindly club it together,
WBC
141
1.
of 2024.
It is submitted by Mr. Fuseko, the learned counsel for the petitioner,
Lordship,
that WPC 141/2024 is similar to the present writ petition. Take WPC 141/2024 along with the present writ petition.
obliged, ma'am.
Item number 14.
Your Lordship,
Yeah.
yeah, I'm here to file my affidavit, so kindly grant me 3 weeks time.
MSAME, the learned government advocate, is allowed 3 weeks time to file affidavit. Okay.
Item number 15.
Here also similar prayer, Your Lordship.
Okay. Similar prayer 15.
Item number 16.
Yes,
Uh,
Mr. M.
I am for the respondent number 1 and 2. I'm
Ah.
yet to receive an instruction. I may be allowed to grant 3 weeks time.
Any other parties? Or only the
Uh,
state respondents?
One mission director is a respondent number 3.
Have you, sir, taken steps for service of notice upon respondent number 4?
Yes, Your Lordship, we have taken steps.
By which order you were directed to take steps? Let's see. Respondent number 4, Mr. N. Mozoi.
And was a mission director.
Yes, sir.
Okay,
Yes, Your Lordship, formal notice. Your Lordship.
yes. N. Mozoi is there, no?
Yes, Your Lordship.
Mr. Im Timso, the learned additional advocate general for the state respondents. And Mr. N. Muzui, the learned counsel for the respondent number 4, are both allowed 3 weeks time to file their respective affidavit in opposition, listed accordingly.
Obliged, Your Lordship.
From the supplementary cost list, item numbers 33 and 34.
What is the matter?
This is about the National Highways Act compensation, madam.
Maybe next time. Next time, we list it for proper hearing.
Yes, my lord.
Yes. All pleadings are completed?
All complete.
Yes, my lord. If, my lord, may I allow, my lord, there is an IA pending in this, WPC 50. IA.
For what?
For, this IA has been preferred by the, present applicant, that is, the respondent 1 and 2 in the main writ petition. For the unlawful obstruction by the opposite party number 1 to 64, who are the, present petitioner in the WPC, as well as, the failure of the district administration to resolve this issue in spite of repeated.
And Mr. Ejimomi, you are representing?
I'm for the petitioners, Mr. Chairman. And the allegation is that we are obstructing the work. We have filed our counter to this application. We are saying it's not true. We have not done any such thing.
Okay, let us hear all the applications on the next day. We'll list it as a hearing item.
Your Lordship, the writs themselves can be heard. Matter ends after that. Yeah, 2 writ petitions, Your Lordship, both connected matters.
We will list the writ petitions for hearing.
Yes, it's already clubbed to here also, Your Lordship. Item 32 and 33. Item 33 and 34. Item 33 and 34. And there is just one IA.
And what is this IA? What is this IA?
This is the one which my another friend is talking about.
Oh,
Yes, my lord. It is to do with the obstruction as well as the failure of the district administration to resolve the issue in spite of making several requests to the district administration.
Okay, we take up your IA along with the writ petition.
Okay, my lord.
Okay, we list the writ petitions for it. It is submitted by the learned counsel for the parties that the pleadings are completed, and therefore the matter can be listed for hearing. Listed for hearing any
The
date.
fourth, fourth, fourth. 4th November, my lord, on the reopening.
Listed for hearing on 4/11/24. The IA 121/2024 shall also be heard along with the main writ petition. Okay.
Lordship.
Much
Lordship, I'm appearing for R7 in item number 34, WPC 216, if Mr. Kekringulia's name can be expunged from the
In item,
item number 34, Lordship. WPC 216 of 21.
here you want Kekringuli's name to be
Yes, my lord.
in WPC 216, okay? The name of Mr. Kekringuli as the learned counsel for the
Respondent number 7.
for the respondent number 7 in WPC 216/2021 shall be deleted. Stop. Registry to take steps accordingly. Okay.
I'm obliged.
Obliged, my lord.
For orders, item number 17.
May it please your lordship.
Yes, yes. Yes.
The petitioners before this honorable court is for claiming land compensation for construction of NH 129A. They have received damage compensation. However,
No land compensation.
no land compensation.
Yes.
I have received instruction recently, but
Okay.
it is not complete. So I may be given some more time
What about
for
me? My dear friend, what is
obtaining clarification.
what is your case? Who are you representing?
Lordship, I'm representing NHITCL,
NHI.
respondent 1, 2, 3. 1, 2, 3.
And Mr. LT,
I'm for respondent number 4 to 8, your lordship.
4 to 8, correct?
Yes, yes, ma'am.
Okay. Will you be filing your affidavit? Have you filed?
Yes, your lordship.
Have you filed?
Yes, your
You
lordship.
filed?
Yes, your lordship.
Okay, good. Mr. LT Sanktam, the learned additional advocate general Nagaland submits that he has received the instructions. However, he would require further clarifications and
Yes.
therefore 3 weeks time.
Yes, ma'am.
Prayer is allowed. This is the case after 3 weeks.
Your lordship, I have taken this step on 9/9/2024.
Against,
Respondent number 9, that's the village council.
have you filed your affidavit?
Lordship, I filed it on 3/10/2024.
By which order affidavit was 310, okay. By which order you had actually taken this Dusty?
9/9/2024.
By 9/9/2024.
Lordship.
Okay. 9/9/2024. Nine.
Lordship.
9/9 is not there. Is there any?
30 July 2024, your lordship. 30. July.
30,
Yes, ma'am.
30 July.
Yes, ma'am.
Ah, 30 July, 30. In terms of the order dated 37/2024, the petitioner has taken steps for service of notice upon respondent number 9 by Dusty process and has filed the affidavit dated 3/10/2024 to that effect. Stop. There is however no representation on behalf of respondent number 9. Stop. The service on respondent number 9 is therefore deemed served. Okay. Okay, next.
For orders, item number 18.
Yes, ma'am.
Lordship, and for the petitioner, Lordship here,
This is 17 or 18?
18, my lord.
Okay.
Lordship here, service of notice upon respondent 11 is still awaited. As per, on 31st May, we have served, registered AD to the respondent number 911.
As per which order?
31st May.
You take fresh steps, ma'am.
Okay, Lordship.
31st May is a long way back.
Okay, Lordship.
Okay, you take fresh steps. After that, we pass necessary orders, okay?
Okay, Lordship.
Your good name?
Vikono Kiso.
MS Vikono Kiso, the learned counsel for the petitioner, shall take fresh steps for service of notice upon the respondent number 11.
Yes,
By what
Lordship.
process? By registered post?
Yes, Lordship.
By registered post with AD within a period of
3 days.
3 days from today, and file affidavit to that effect. Yes, what is your case, ma'am? You have filed your affidavit?
Yes, Lordship.
You have filed your
Lordship,
affidavit?
the state is due to file
Ah.
3 weeks time in granted, Lordship.
MS Pichano, the learned government advocate, is allowed 3 weeks' time to file affidavit in opposition on behalf of the state respondents. Listed accordingly.
I will-
Item number 19.
May I please, Lordship,
Yes.
on behalf of MOA, kindly grant 3 weeks time to file affidavit, Lordship.
Okay. MS Pichano makes a, learned council makes a mention on behalf of Mr. Moim Chin, the learned senior government advocate, and seeks adjournment of the case for 3 weeks to file affidavit
Affidavit, Lordship.
in opposition. Prayer is allowed, listed accordingly.
I obey.
Over.